My name is Dr. Susan Breaux, and I have the great honor to be the Dean of the Faculty of Law at the University of Victoria. And it is my distinct pleasure today to introduce to you Dr. Tracey Lindberg. Dr. Lindberg joined our Faculty of Law as a full professor in July of 2020. Prior to that, she was a full professor and research chair in Indigenous laws, legal orders and traditions at the University of Ottawa Faculty of Law. She is also a citizen of the Kelly Lake Cree Nation. She studied Indigenous studies in her undergrad and holds an LLB from the University of Saskatchewan, an LLM from Harvard University, and she received her doctorate from the University of Ottawa. In Ottawa, she received the Governor General's Medal, Gold Medal for her dissertation, Critical Indigenous Legal Theory. She is also a writer of fiction. Her novel, Birdie, was a finalist for the Kobo Emerging Writers Award and the 2016 edition of CBC's Canada Reads. From 2010 to 2015, Dr. Lindberg held the Canada Research Chair in Indigenous Legal Orders, Laws and Traditions at Athabasca University. She is also a Fellow of the Royal Society of Canada's College of New Scholars, Artists and Scientists. And her research interests include traditional Indigenous governments, Cree laws, and the translation between Canadian and Indigenous laws, Indigenous women and legal advocacy, and activism by and for Indigenous peoples. She brings all of those skills and research interests to the world's first Indigenous law degree that was launched at the University of Victoria, and she also teaches in our Juris Doctor program. Her current research and creative interests are engaged in her completion of a documentary, novel, and nonfiction text, all of which engages Indigenous legal orders, teachings, and knowledge.
Hello. My name is Dr. Tracey Lindberg. I'm a professor of law at the University of Victoria's Law School. I am thrilled to be able to be here today and speak with you and engage with you in some ideas that are near and dear to my heart and which are germinating all over Indigenous law country, wherever that may be, on this Turtle Island or around the world. I wanted to be able to have a conversation with speakers who are and thinkers who are addressing early in their education ideas and thoughts of the crossover between Indigenous laws and legal orders and state laws and legal orders, in this case, Canada, Aboriginal laws. So what I'm trying to do is to be able to have a conversation with you, a dialogue one way this time, that allows you to understand and approach Indigenous laws and legal orders as meaningful laws and legal orders, but also as information and knowledge that can be engaged with, can be critiqued, can be accepted, understood, misunderstood, or rejected. So I'm going to tell you that today I'm thinking of Indigenous law as a responsibility, centering Indigenous laws, Indigenous peoples, and Indigenous legal orders in your learning and practice. In order for me to be able to do this with any sort of real structure that feels like maybe we're in the room together, I will conduct myself as though we're sitting at a coffee table or sitting at a kitchen table having a conversation. But I will structure it so that it's something that people can use in classrooms or follow in classrooms as well. So I would ordinarily, in any speaking engagement or any place where I was invited to talk, engage in my language and then explain and express to you what I've said. So I will do so today as well. Tanse ne wake maganak ke te tamska e nawa ama ke taskewa ke beta golan egwa mina nina na skoma wa gojik kape wi samchik kape wi sikwia. Hi. What I've said to you is that I'm thankful to be here. I'm thankful to be on this territory, and I'm thankful to the original peoples. I'm not at the University of Victoria campus, but I am on territory, the traditional territory of the Lekwungen and Saanich peoples. I recognize their relationship with the land and my relationship with it as well, and I'll tell you more about that as we go along. I want to thank the people who invited me. Thank you to my relatives in this virtual room, and thank you to all of you for making the time to listen to it. For today's discussion, we'll look at expanding our understandings of Indigenous laws and legal orders. We'll look at the importance of relationships and responsibilities in our thinking about those Indigenous laws and legal orders. My very broadly stated idea or proposition is that Indigenous laws are still operating, are still operational, and are useful. Further, that provincial and federal laws may be algae that is growing on the bedrock of Indigenous laws and legal orders, but to make no mistake, they're still here and still active and providing the grounding for other orders that have joined after settlers came to our territories. And finally, I'm going to talk about our obligation as peoples with a relationship to land and how that relationship to land necessitates a reimagining of our obligation to the territory we live on as an active and law-abiding obligation. So I'll talk to you initially about the introduction. I'm going to talk about acknowledging specifically. To contextualize this, introduction is an acknowledgement of the way of noting the ownership and occupancy by original peoples to this territory. I undertake the recognition not as a land acknowledgement, which I'm pretty certain most people are aware of now. I try to think of it as a legal responsibility. In my younger days, when I was working through the idea of how you acknowledge whose territory you're on and why you need to do that, I used to say it's like a passport. When I say this, I'm showing my passport to the Lekwungen and the Saanich people, would have been the way that I talked about it as a younger, potentially more naive, but not as hopeful law student and legal thinker. I now think of it in terms of authority, agency, jurisdiction. And that passport metaphor helps, but what I'm looking for specifically is, do I have the right to be here? Do I have the right to be on this territory? Have I acknowledged the laws that are operational? Have I acknowledged the land relationship of the original peoples to this territory? Do I know what the laws are? I know that where I come from, I'm a Cree person, Cree mom, Scottish and Swedish dad. And in Cree territory, Sylvia McAdam tells us that there was a way to guarantee when you got to the border of somebody's territory that you could get confidence that you had heard from the authorities about whether or not you could stay on that territory or not. In the old days, or back in the day, they would put a stick or put something memorable onto the territory of the people whose land you were encroaching upon. If when you came back the next day, the stick was taken or the gift was taken, then you had a right to go onto the territory. If it was not, then you couldn't have passage or legal passage in that regard. And I tend to think of that as what we should be doing and what we should be engaging with. I know that there's 1,000 reasons and 1,000 colonizing ideas and 100 colonizing acts that might pull us away from that. But I think that it makes it even more important that we sit back and take with seriousness the idea that we are entering onto somebody's territory, we're entering onto somebody's land. Also, that idea of passport, the idea of a stick, to me starts to talk about proactive and an action. And while this language isn't enough, it starts to allow me intellectually to move towards undertaking, my undertaking to provide recognition of the keepers of the land and their relationship with the land. Because in that sense, we talk a lot about Indigenous laws, but we are not performing Indigenous law. We're not adhering to it in other than an intellectual sense. What would it be like to come onto Lekwungen and Saanich territory if I was being law-abiding? So I'm trying to think about what the action is, and the action is something that I do. Dr. Val Napoleon tells us that law is something you do. So when I come to Lekwungen and Saanich territory, I think about what is it that I do? What is the action necessitated or required by the laws here? It's not just recognizing the original occupants. We lawfully acknowledge their sovereignty and our commitment to it when we engage in a conversation like this. So I start to think of law not only as a responsibility, but the territory and our relations with it as important. In doing so, I also recognize that the relationship with the original peoples on this territory, and in this case, I am on and am recording from the territory of the Lekwungen and Saanich peoples, as I stated, as sovereign nations and authority, and with right to control. That is, in order for this to be more than a cookie cutter land acknowledgement, I commit to the authority and jurisdiction of the original peoples. As a person unrelated to the land that I am on, except by nebulous or tiny threads or strands, and I would have to say, as an Indigenous settler, I am settling on an Indigenous people's land that is not my own, that I don't have permission to be on. I have to acknowledge that my settlement takes place at the cost of the original peoples. At the cost of the original peoples gets us into a mode of thinking and philosophy about exchange, which isn't useful for this. I do want to talk about reciprocity and reciprocal back and forth of adhering to the law, following the law, and bettering the territory you're on with approval from the nation that resides there or whose territory it actually is. So I kind of try to think myself as well, because this is not my territory. I come from Kelly Lake. I come from territory that's near mountains, but also has farming and that has entirely different characteristics than the territory that I'm currently on. But I chose to live here, and it's a privilege to be able to live here. I'm trying to figure out, how do I perform this legal obligation? How do I find ways that I can build relationships that allow me to be here without doing harm, that allow me to be here while acknowledging the territoriality and sovereignty and self-determination of the nations original to the land? And how do I facilitate that back and forth of the benefit that I get from this land and what I give back to the land and the original peoples? So I think that a lot of this takes us to a conversation about territory and relationships. And I don't think that it's necessarily enough that I recognize that this is Lekwungen and Saanich territory. I don't think it's necessarily enough that every person in my neighborhood recognizes that. But that idea that recognition is enough, or recognition can catapult our conversation into a place where Indigenous peoples can require that you don't come onto their territory, that's all difficult and a place that we can get to by putting some building blocks in place. So I tend to ask myself and ask people that I work with, what does recognition mean? What does recognition of your relationship with this territory mean? It can mean a lot of things. For those of us struggling with our relationship with territories that are not our own, it means we honor and create space for the original peoples to perform their legal obligations as relatives of their territory, as they are relatives of their land. We think of the land, the earth, the water, mountains as animate in the Cree tradition and as a legal entity, for lack of a better word, with rights. So if in this conversation today, if you can silence your disbelief and think of land as a person, which is troubling for all sorts of reasons, but if you can just think of land as a person, it gets us to the point where we have to recognize the animus, the animation of it, but it also makes it easier to understand some of the discussion as we come upon it, including our discussion as land as a relative. I think of this specifically as grounding ground, where I'm laying down some solid foundation for us to be able to understand the whole of the relationship with the land. That whole trope of Indigenous peoples are at one with Mother Nature, that the earth is our mother. Parts of these things have their embryonic existence or have their recognizable, cognizable existence in something that is actually true or a truism. I tend to think about land as a relative as the whole trope, the legal truism that you have a legal obligation to your relatives. if you can start there and think about grounding that and the legal obligation you have with your relatives, your children, your parents, your mother, your father, your nieces, your nephews, those obligations are different depending on the nature of your relationship with it. For many Indigenous peoples, and I'll include myself within this, we consider that relationship with mother, father, grandfather, grandmother, children, nieces, nephews to also include land, water, mountains, that those are relatives as well. I don't have the same relationship with all relatives. I don't have the same obligation to all relatives, but that notion of relationality and how you understand yourself within a community upon the land in relation to the original peoples is really an important one. And I'm going to expand upon that a couple of times within the discussion today. We're also going to, in that discussion, talk about as a relative the law that governs our interaction, our responsibilities, our limitations, depending on the nature of our relationship. My rights as a visitor to this territory exist only to the degree that the original peoples framed them. I'm a settler in these relationships, and my relationship with this territory has to be predicated on the notion of the flow back and forth of reciprocal obligations between myself and the land. You will have seen in your life and in your studies and in your thinking, you will have seen you have to begin to look at, in introducing yourself to this discussion and in the centering of Indigenous peoples and Indigenous territoriality, it necessarily includes a discussion of you as a relative to the land, as a relative to the original peoples, and talking about the authority, the jurisdiction, and how the laws within those communities can and do actually govern your interaction, your responsibilities, your limitations, and how the nature of your relationships with the land and the peoples can dependably allow us the possibility of living Indigenous legal lives, or Indigenous ethical lives as well, legally ethical lives, depending on your relationship. So I keep thinking about myself on this territory and my rights as a visitor to this territory, because in Canada we often speak of, in North America we often speak of rights, and I'm trying to shift that idea from a rights holding person to an obligation or responsibility carrying person. What is my responsibility, my obligation as a visitor to this territory, to the Lekwungen and the Saanich peoples? Because I am an Indigenous person who lives on their land, I am settled on their land. I am a settler to a certain degree. And as a settler, all of the Canadian law, all of the Western law, all of the common law has been worded, framed, and established in ways that allow for the taking of Indigenous lands from Indigenous peoples. So I can move on to the territory and say, well, that was all done years ago. But that's a living colonization that I don't want to be a part of. So I'm trying to find out in this regard how to live respectfully and law-abidingly amongst the Lekwungen and Saanich peoples, and how I can live on their territory. As a visitor to this land, as a settler to this land, I owe at the very least respect. At the very least, this respect includes knowing that because this land cares for me and keeps me well, and I have the privilege of being on it, that I have to, not as an intellectual exercise, but I have to, as a commitment to Indigenous peoples whose territory this is, I have to here on this land acknowledge that I get a benefit from pushing the people originals to this territory off of it. And that's a hard thing to get my head around. That's a hard thing for a lot of us to have a conversation about, that we are benefiting from that violence, that colonial violence that was passed down to us, that becomes part of the colonial legacy. I don't want to be an Indigenous person who colonizes or recolonizes or who does violence to Indigenous peoples through colonization. So the reason that we end up here having this conversation is because we get to the topic. How do we honor this relationship? And what does a legal relationship with land as an entity, or land as a legal personality, land as animate, having animus, what does that look like? So I'm going to talk about that today. I'm going to start with a few introductory definitions so you can know where it is that I'm coming from. I'll start by utilizing the word Indigenous in most of my conversation. When I can, I will refer specifically to peoples whose territory that I'm on. I will refer specifically where I can to my own nationhood. And to have a conversation that is intellectually accessible to all of us, I'm going to use Indigenous to mean peoples original to the territory. If I was at a kitchen table talking to my nieces and nephews, I'd say the land that our ancestors' bones are ground into for forever, beyond time immemorial. So I utilize that term when I'm talking about Indigenous, and I expand upon that definition when I'm thinking of Indigenous laws. I'm utilizing Val Napoleon's discussion of law is something that you do. So Indigenous law is something that Indigenous people do. In the context of this conversation, I'm asking you, what will you do to demonstrate your relationship to the land you're on and to the original land keepers? When I talk about Indigenous legal orders, I'll be talking about the way we organize legal theory and principles in broader packages for discussion and thinking. And I'll try to distinguish where I can between a law and an order, if I can do so. When the term traditional is used in this context, I'm not using it in a way that speaks to, and it can be used as traditions of Indigenous peoples in a cultural sense. I tend to think when I use traditional that I'm looking to historically related or ties to historical understandings, beliefs, or activities, but that's not necessarily ascribing a rightfulness or a righteousness to it or to a lack of it. Indigenous peoples are living, Indigenous laws are living, and the laws change and go forward to the current day. So I try not to historicize while utilizing the term traditional. When I use the word territory, I'll be thinking of it as something that has animus, is animate, and it's inseparable from the lives that share it. That can be human lives, but there's other lives, four-legged lives, guild lives, fire, stone, trees. That idea of territory is responsible to the land and between the land and other entities. What does that responsibility look like that I have to Lekwungen and Saanich territories, that I have to Lekwungen and Saanich peoples? In order to be able to have a full conversation about this, I do have to talk specifically about relational effects or relational adherence. For this discussion, if we can think of relationality as a link or the obligation between the land and ourselves as relatives, I think that will go far. I'm also going to be utilizing every once in a while the term reciprocity. And while I deliberately tried to eradicate the notion of a medium of exchange for you when discussing the back and forth, that back and forth of obligation, responsibility, benefit, obligation, responsibility, benefit between Indigenous peoples and non-Indigenous peoples, between Indigenous peoples and Indigenous land, between non-Indigenous peoples and Indigenous land, between Indigenous hunters and elk, moose, buffalo, bear, that reciprocal obligation, the back and forth, an obligation that flows back and between, to and from, is what I'm speaking of. So generally a one-sided or exhausting or colonial approach doesn't have that flow back and forth between the obligations. We're trying to think about law as one of those obligations, one way of the flow. I'm also going to be using a Cree understanding of the word is called Wakotoan, and the notion behind it is that you have a legal obligation to the degree that it corresponds with your good relations. That is, if the legal principle in a Cree contextualization, contextualization is that you have good relations, requires that, then Wokotowin becomes the way that you govern your conduct accordingly. If you have to have good relations, how do you govern your conduct accordingly, depending on the nature of your relationship? And I'll speak to that a little more broadly in a moment or two. So in these legal relations and situating yourself, there's a lot of questions that I say and think of when it is that you first meet or when you first come to a piece of land. Who is your family is the first question that lots of people ask. Lots of Indigenous people ask other Indigenous peoples, but lots of Indigenous peoples ask of peoples who they meet or going through their territory or whose territory they're on. Remembering the nature of your relationship to be determinative in establishing which law impacts or is applicable to you, shades of Wokotowin. It's important because you are not just obliged for your generation, you're obliged for multiple generations in many Indigenous people's teachings. And by situating, geopolitically locating, culturally locating, linguistically locating you and your family, then the nature of your obligations to that territory becomes clearer. I'm clearly not a Lekwungen or Saanich person. I'm not from those territories. I'm not from that understanding. So my obligation looks different, even though I'm an Indigenous person here. I'm from Kelly Lake territory. That's the second line of inquiry. Where are you from and who are you? Where do you live? To some degree, this allows us to start to engage in conversations about parameters of law. How far does the obligation extend? What are the legal requirements that extend? What if somebody from Lekwungen territory came to live in Kelly Lake territory? What would the legal requirements be? What would the bundle of sticks look like that the Lekwungen people had to put down at the border of Cree territory? What does the bundle of sticks look like that I have to put down at the border of the Lekwungen and Saanich peoples? That where you're from and where do you live gives you the parameters of jurisdiction. And it can give you not only the understanding of territorial jurisdiction, but the legal jurisdiction that exists within that territory, whether you see it or not, it's there. So what is your relationality? Think, what are your responsibilities with respect to your family and community? What are your roles and responsibilities to this land? The land that you're on right now. What is your responsibility to the families and community that are the land keepers, that have the jurisdiction and authority by virtue of not just historicized understandings of their relationship with land, but the acknowledgement of their relationship with that land from all the peoples around them? What laws are in place? It's my obligation to learn the laws and know the impact that they have on original and settler occupants. And when I say settler, I am speaking to some degree of people, but I'm also talking about those little lizards that have shown up, those little simple, what do they call them, wall climbing lizards that are an invasive species in Victoria. What does invasive mean in that regard? Are they settler lizards? What is the responsibility that they take on as elements and entities that live within that territory? What about those blackberry bushes all over Vancouver Island that are not natural to this territory, I understand, or I've been told? What is our obligation? And am I an invasive species as a Cree person coming to live on this territory? What is the flow back and forth that I can understand, that I can develop, that the original peoples can depend upon? Is the legal question. So I ask, within my own territory as well, I have to learn the laws for where I am. I'm going to discuss that specifically in the last part of this talk today. But learning where I'm from and what my obligations are on our own territory, but also as I travel to other people's territory. So when I go to another person's land, I'm often aware of and try to be sure that I find out the historical, legal, linguistic, cultural relationships of the original people's territory. Whose land is this? I asked that of non-Indigenous peoples, I asked that of Indigenous peoples, and I first try to make sure that I take an attempt at it, so I'm not requiring too much energy of anybody or anybody else who might be swamped with the politics of identification and recognition. I have a little niece named Sophie, and Sophie is a settler. Sophie has known since she was a child. I think she was 5 or 6 years old when she went onto the territory of the Musqueam, and she lives in Ottawa. But she'd gone visiting in Vancouver, and they were at Stanley Park, her family and another family. And Sophie, as a child, 5, 6 years old, turns to the family and says, "I live on Algonquin territory. Whose territory do you live on?" And they didn't know. And I know that it seems simplistic and it seems elemental, but I think that that idea of knowing whose territory you're on is the sort of opening place to be able to have discussions about what does that necessitate of me as a visitor? What does that necessitate of me as a settler? What does that require of me as an auntie? What does that require of me as a person who's not regular to this territory? So for me, I make a commitment whenever I move to try and, to the best of my ability and within respectful parameters, not participate in an extractive exercise where I'm taking information in because it benefits me. I know that I have an obligation and I have to find out what that looks like. So I have to, in order to be able to understand that, find out the laws and legal orders in the place where I'm living or where I'm traveling. So part of this, while I'm traveling, while I'm moving, while I'm living on Indigenous people's territory, while I'm on my own territory or other Indigenous people's territory, part of finding and interpreting the legal boundaries is coming into what I like to call the amorphous blob. The amorphous blob is sort of the idea that you move into a territory and there's municipal laws in place, there's provincial laws in place, there's federal laws in place, there's laws of the land that people are operationalizing and using every day. We ignore that stop sign. We do 20 here, not 40. There's an amorphous blob of laws that are there. But in order to best understand the legal boundaries, the Indigenous legal boundaries in the territory that you're on, you have to require more of yourself, thinking of the impact of colonial, racialized, and gendered violence and Indigenous peoples on that land. Examining the multiple oppressions that Indigenous peoples face and understanding the impact that these will have on people, families, communities, and nations. It requires of us that we don't just look at the colonial blob, the amorphous blob, and say, well, there it is, but that we try to look to the particulars, that we try to look to the understanding, that we require specificity and not a pan-Indigenous approach to our learning, and that we don't abscond with the learning, that we take it, use it, bury it, apply it in ways that are useful to the people who were gracious enough to lend it to us as a gift. I also think that the amorphous blob requires that we recognize our positionality, our privilege, and our relationality to the land that we're on. I get to live here. There's no actual physical requirement that I pay taxes to the original peoples, but I can do that. I can also be the lawyer who develops a structure, a planned giving where you, upon your passing on this territory, any profits from your property go to the Lekwungen and Saanich people. Any profits, the land reverts back to the Lekwungen and Saanich peoples. We have a lot of ways that we can do this that just require us to separate ourselves for an instant from the idea that man, human person, is at the top of some pyramid above earth, animals, other humans, other creatures. I think that our obligation is to look to the obligation of other peoples and see how we have framed or disrupted their ability to perform law So I also ask people when looking at the Amorphous Blob to consider the violence in neutrality, that there's not really a neutral in sitting there and not doing anything and not making an active choice. That with that positionality, privilege, and relationality that you have all sorts of opportunity and all sorts of abilities that are useful to an indigenization, an indigenous resurgence, and honoring of indigenous peoples and territories, and developing your relationship with the territories and people. So we've discussed that. These notes are available for all of you to utilize yourself. Also, when approaching that understanding of the interpretation and finding the legal boundaries, I try to remember the D or engendering and the remembering that takes place in the modern day interpretation of Indigenous relationships with land. I think that I try to sit back and always think of the danger of binaries, that when we think of Indigenous societies and communities and non-Indigenous societies and communities as having multi-genders and having many different possibilities for sexuality orientation, that the realities of egalitarianism in Indigenous societies are that there are multiple genders. They were and are recognized, not in every place, not in every family, not in every community, because colonization has a number of violences that it does, but the continual erasure of Indigenous women, Indigenous people who identify as being on a continuum of sexuality, a continuum of identity, is something that we have to take responsibility for because we know what's going on. Part of this dean or engendering or un or miss or re-remembering also means that we have to look to the roles and responsibilities not as gender fixed categories, because that does damage. And it simplifies it to say all women do this, all Cree women do X, all Cree men do Y. Well, then, if that's true, which it rarely ever is, then everybody in between, around, underneath, pinning up, lifting up the genders of man and woman becomes silenced, and we lose a possibility and potential and the loveliness of discomfort and life, because we have disrupted our binary thinking. Disrupt your binary thinking. I also think that in this discussion of roles and responsibilities, that those gender fixed categories do damage. I also think that ratio sexual stereotyping, Canadian legal history, and the way that even caregiving and caring people can do damage can be given evidence in the discussion of missing and murdered Indigenous women, because there is a high relationality with our women and our girls, and with two-spirited peoples, and with people who identify as gay, lesbian, bi, asexual, intersex, that there's a lot of violence that happens within that continuum as well. That when we fix ourselves to the binary, when we de-gender, or we engender, or we misremember, that we are leaving a lot of the conversation out. Just as a short side note, I do note that this is a story shared in a public space, so I don't feel uncomfortable echoing it within this. Sylvia McAdam had written on social media that she was participating in ceremonial rites. She was participating in the law, the continuing of the law from one year to the next by purifying herself. And by doing that, she was fasting at the time. And she wore a skirt because she was always told you wear a skirt to those ceremonies. And something started rustling in the bush next to her. And she hopped up and ran, or she thought about hopping up and running. and in doing so knew with clarity that there's no way that people were fasting in skirts. No way people would go off into the territory and be able to defend themselves appropriately if they were in skirts. That's her truth and her understanding. And it's a place I come back to quite frequently when I'm trying to distinguish between tradition as a handcuff and tradition as a springboard. Does tradition allow you the conversation of what would necessarily be a natural? How do I interrogate? How do I, without cynicism, but with kindness, critique and engage with ideas of traditionalism? That, violence against BIPOC, violence against people self-identifying as participants within the continuum of orientation, sexuality, gender, that we continue to do violence and we don't unpack that or have the possibility of the unknown guide some of our thinking and some of our hoping and some of our inclusion of peoples, that we have to continue to think of the iteration of law and the discussion of law as formed by or supported by kind inclusive means. So if we do that, we're much better prepared to render accurate possibilities and potentialities. So, sorry, this one's hopped a bit ahead here. I do want to talk about spectrum and spectral beings as well within this conversation. The possibility of spectrums, engaging cataloging versus knowing that there's lots of things that we're not going to know, we're not going to understand, and you don't have to pretend that you do, that you can still be radical and you can still query teachings and query the education that you get and query, engage with, ask questions of elders, knowledge keepers, shaman, I think some people use that, medicine people within our traditions, that you can have those conversations. The real struggle in this, or the real difficulty, is ensuring that you acknowledge your position as a person who has privilege. You acknowledge the privilege that you get by living on the territories and the land and from the people who are original to that land that you're on. And just as there are a spectrum of Indigenous knowledge holders, there's a spectrum of allies, allyships, and informed ally participation. And all of that can have ways and means of expressing itself and can appear upon a spectrum or a continuum of understanding that you can journey through. You don't have to feel that you're not enough. Where you come from is where you come from. The teachings that you bring to it are important, but recognizing that we don't get it all and we don't know it all, that they're spectral beings, allows us participation on an intellectual spectrum or continuum that I think is important. And then as people who are living within differing societies, maybe a medicine society for Indigenous peoples, maybe a buffalo rope society, maybe a women's society, maybe a Canadian society for some people, that anti-colonial work is an obligation and responsibility that comes to each of us. I think that we have to move beyond the notion of decolonizing our relationship with law to thinking about with, not for, not instead of, but with, if invited, Indigenous peoples' leadership authority and permission to look at anti-colonial approaches to understanding Indigenous autonomous relationships with individuals, families, communities, nations, and institutions. I think that we have to look at Indigenous peoples and understand Indigenous peoples as actors, not reactors. And when reading the news, it's really important that we sit down and think, how am I perpetuating this potentially stereotype? What agency is engaged here? What responsibility is acknowledged? And how does the Indigenous legal narrative fit or not fit within this? I think that, as I've said on the slide, that creators, innovators, and active agents who have systems, processes, and substantive understandings of philosophies, laws, governments, and societies inherent within Indigenous knowledge systems and Indigenous ways of knowing. If you can engage in those relationships each time you travel, each day that you're on someone's territory, each day obliging yourself to learn the traditions and to learn the laws, to learn the philosophies, or to develop the framework to be able to interpret with intelligence what it is that you're learning, I think that is not a kindness, it's a responsibility. But you can undertake it with kindness, and you can think of your responsibility to be kind. How am I benefiting from this? How might I ensure that I am flowing back or pushing back some of the gifts that I'm getting from the territory or from the people? I think that part of anti-colonial work means understanding that the work that we do is not a response to colonialism or colonial violence, but what we're all working towards is a renewal of health, a renewal of Indigenous communities, families, societies, nations, and getting a better understanding of what Indigenous inheritance, responsibilities, and actions look like. For me, I have to think I'm a law professor now. I live on the territory of peoples original to it, and I have the benefit of living safely, healthfully, happily on that. What has to flow back? For me, recognizing the obligation to learn the laws and understand the processes and start to ask people, what do you think of? Not requiring people to do the work for you, but starting to think, what if I queried whether or not this park, Dean Park itself, the mountain upon it, what if I thought that it was not necessarily useful to limit Indigenous activity in this territory? How, as an ally, can I make sure that the original peoples have a relationship without imputing myself into that? How do I talk about renaming and involving the way that we talk about law, the way that we talk about relationship with territory, by sitting down and talking to the leadership of this community about ways that we can maybe assist with the mapping, cultural mapping, geographic mapping, linguistic mapping, depending on what your skill and your tool set are, bringing them to the Indigenous nation and saying, I hope that you will avail. How can I participate? And I know that's asking a lot. We're busy people with obligations, but the idea that we can continue to go on not acknowledging and not welcoming and not supporting and not renewing relations with Indigenous peoples and participating in the renewal of society spaces and communities that regard Indigenous familial relationships as important enough to support, that all needs to be examined, that all needs to be looked at. And I think that these are tools in people's toolkits that if we don't have to drive, if we can recognize we're not the drivers, that we're just participants that are invited in once in a while, or we're participants who are invited in, or we marry in the nature of our relationship with the peoples on that territory, if you were coming from a Cree legal perspective, would define what your obligations and responsibilities were as well. Find out what your responsibilities are. You don't have to fulfill them or fail to fulfill them or feel like you're a failure because you don't. Just engage with the possibility that there are legal responsibilities to the original peoples and to that land itself, and do the work. Find out what those look like. I think you'll be altered by it. I'm altered by it every day, depending on where I travel to and where I go. So, in this discussion of thinking of law as an action, I want you to think of Indigenous law as a positive obligation, just for the duration of this discussion, and you can stop thinking about that afterwards. But I'm going to discuss law as an action, a positive obligation, and I can't discuss it from the territory that I'm on because I've been in lockdown since I moved here and haven't been able to meet people or follow the protocols that I will be following and the peoples that I will be meeting and to whom I will offer my toolkit. So I'm going to relate back specifically to my experience and my understanding, for examples of how to live, interpret, and honor these laws. And I also want to talk about myself as an agent who has the responsibility to oblige or be obliging, and how that requires that I shift from the language of rights, Indigenous rights, Aboriginal rights, but shifts to the understanding of my obligations and responsibilities. And I'm thankful to my late friend, as she was known, Patricia Montour, for teaching that and writing about that. So I'm going to talk to you first about these 4 places, these 4 laws, these 4 understandings coming from where I come from, which is an urban Indigenous population, quite truly, because I have not lived in Kelly Lake territory since I was a toddler, and have lived, I'm 3rd generation urban Indigenous person. So the pieces that I have to understand this come from a variety of places. I don't say that they're any less sacred than teachings that people receive when they live in community, but not speaking my language is an impediment or a barrier that I have not yet overcome to be able to understand it. The things that I do understand and the mistakes that I make from the interpretation are my own, and I acknowledge that because I don't want anybody to run off from here and say, all Cree peoples think this, all people from Kelly Lake think this, all Tracey Lindbergs think this. This is one person. And this is the way that I think of law as an action, giving voice to and place to the fullness of the conversation that we had about recognizing law. So I'll start first with the idea of Monsoon. The notion within a Cree contextualization is that in Monsoon you have an obligation to live a good life. If I think of it as a constituting principle and not a constitution, the idea that there is a precedent, a legal precedent, as a way to aggregate activity and think about the way to best live. I don't think of it as criminal law that says if you do X, your punishment is Y. It's the expectation is that you will A, and we have precedent to tell you what happens if you do B. And that, I think, is important for a number of reasons. The first is to recognize that the ongoing nature of law is that within a lot of Indigenous contextualization, certainly within a Cree context, that the responsibility doesn't just fall to you. When people are asking me who my relatives are, they're not just asking to find out where I grew up, what I know. They're also trying to find out what my relatives' ability to or representation of the good life look like. And people will know that for generations before you. But it also is a reminder that we have to be aware of what the good life means for upcoming generations, not just our past ancestors, but our future generations. And we've all heard the discussion of 7 generations. You have to plan on it. If you can think of that repercussion of behavior, the repercussion of not participating in a good life means that there's a precedent that follows you until it's righted, and that can last past your lifetime. And to me, that's always hard for people to understand and get their head around, but it's an important factor that good life, and it's not necessarily good versus bad, or hybridity or dualism. It's to look to the characteristics, the principles, the continuity of behavior that would allow you, your ancestors, and your next generations to live well. And there'll be 1,000 stories where people tell you, without telling you, how not living well has a consequence, how not interpreting the good life is painful. And those things, I think, when we go generally to other people's territory, I ask myself, what is the good life like here? What does the good life look like? What is the constituting principle on Lekwungen and Saanich territories? What could that look like? that's my intellectual task. I have to find out whether or not that's a legal standard that people here live by. And I have to find out what that obligation looks like when you're living on the territory. The next thing, and I spoke to you about this very briefly in the beginning, was Wokotowin. From a Cree contextualization, and I owe my understanding in this a lot to the writings of Sylvia McAdam, and speaking with Sylvia McAdam and Harold Cardinal, and Harold Cardinal's writings as well, on behalf of the Treaty Commission in Treaty 6 Saskatchewan, that Wokotowin, that idea of family relationships, the idea that you have an obligation to have good relations, and that Wokotowin tells you what the nature of your obligation is depending upon the relationship that you have. So if I say the earth is my mother, I have an obligation to treat my mother well. I have an obligation not to poison my mother. I have an obligation to celebrate my mother. I have an obligation not to pollute or treat disrespectfully my mother. That family relationship defines the nature of the legal adherence that I must subscribe to. But also the idea that family relations, I have people whom I love and adore and whose territory I have lived on before, whom I have a family obligation to, because I have been there enough to be recognized as a family member. It doesn't mean that I am now a citizen of their nation, or I am a member of their nation, or I am a blood member of their family. What it means is that some of those legal principles, those positive obligations that come to me not as a stranger, where the minimum modicum of lawful behavior would be respect, but come to me as a family member who has access to different teachers and different understandings. And it's beautiful and obliging, but there is an obliging feel to it. As a person who, Wokotowin, comes from Kelly Lake Cree, who has a sort of, when one of the leaders, when introducing me, always says that I was adopted out of the community. And I was not. My mom's Cree, and my dad, as I said, is Scottish and Swedish. And my dad took us to small northern towns to live in. So that idea, I used to be offended when I'd hear them saying that I was adopted out. But I came to understand what it meant was that there was a disruption in my relationship with the community, and that my knowledge level was disrupted as well. It doesn't mean that my obligation to find out those relatives, to learn the language, to build the relationship with the territory have ceased. It just means that there's a public acknowledgement that they've been disrupted and interrupted, and that my family relationship as a person who was adopted out has resulted in new understandings and new legal obligations that probably are based upon precedent when people married outside of the Cree community, or when people moved away, when someone gave up, when a grandparent took the oldest child to live with them as a companion and as a child, that those fluidity of relationships are certainly there, that there's cessation of relationships, interruption of relationships, but that it doesn't have to be forever, that you can build those relationships and within a Cree legal context, do it on the basis of Wokotowin, which will determine the code of conduct that you have with people. I think that it means that the community that I come from, Kelly Lake, that they have a lot more patience with me than I do with myself, that I get to be thought of as a little kid in a lot of ways, but that my responsibility and obligations are those of an adult. So I hope that clarifies it. Just from the conversational piece, I know that this is true in a lot of, or some Anishinaabe territories, that this is true in Mi'kmaq territories, some Mi'kmaq territories, families, communities. And I know that this is also familiar to a lot of people who speak Cree from differing Bush Cree, Plains Cree spaces as well. I want to talk just for a moment about Tepwewin as well as law as an action, in the idea that the words that you have matter. I remember reading years ago an author who said that you had to carry the words that you put out in the world behind you, like on a sled, and you had to carry that for life. I think about that often, that the lies that you tell, that the truth is a much lighter pack to carry if you need to relocate, or a much lighter pack to carry with you for your life. That also, because of that notion of Wakotowin, the truths that you don't tell can be part of the burden that your generations ahead of you, the generations behind you, the children will have to carry. Somebody told me that Tapoewan means that it's the heart truth, that it comes from the heart, and that we are obliged to speak with the heart truth. And that's a hard place to live in as a modern day citizen who participates within the overlapping intersectionality of different nations, communities, provinces, cities, but also that lives within differing obligations, legal and ethical, from all those places. How do you speak your truth so it doesn't cause you harm, doesn't cause other harm? And as a legal obligation to try and commit to telling the truth or not saying anything, which I think is something my aunties and I have talked about and laughed about as a Cree non-answer. It means that they don't want to lie to you, that your family doesn't want to have to put that lie out there, so they will say nothing. And it's become very, very difficult for me as the person trying to understand and inform modern day conceptualizations of Nihia, of Cree legal theory, trying to correspond that with Canadian or British Columbia or Alberta or Saskatchewan or Ontario legal notions of the requirement to do something. And then that place where they come up against each other, the requirement to be a certain thing, is what I think that law as an action speaks to. Be a certain way, be truthful, live the good life, take care of your relatives. That sort of understanding is really difficult when you have it rubbing up against the cultural, linguistics, legal dissonance of the Criminal Code of Canada. These are your legal obligations. These are your legal obligations that have necessary punishments that you can that can fall to you if you do it. That space in there is uncomfortable and is often the place where terrible discussions go online or in the comment section of newspapers. But that's where most of us live, is trying to figure out how that friction serves or does not serve, and what benefit or harm it can give or do. The last piece that I wanted to talk about was a notion from pre-understanding. The word, when I've heard it pronounced by people, is kiam. Kiam, and then this is it's the hand motion that people have when they're talking about it. And I've come to understand it as, depending on how I am in my growing and growth journey, and depending where I am at the time, I've thought of it before as mind your business. It means mind your business. I've also thought of it as keep your eyes on your family, no judgment of other people's choices or selections. And I don't think that I understood it as a positive obligation, as a way to live your life, until I looked at land claim or land invasion negotiations in northern Alberta. And I saw that the government of Canada was having a conversation with a group of families who identified as one nation and were ignoring the other families who identified as a nation. And that for the people who were not being acknowledged and not being spoken to, they put real effort into not looking at or judging or asserting negative feelings or understandings against those families who were amenable to Canadian relationship and sticking to their own business. Their own business was to protect the land, and that they couldn't take anything individually or collectively unless they could assure that the land would be taken care of. Kiam. Not snobbily, mind your business, but remember what your goals are, and don't throw violence at the people who don't have the same goals as you. is the way that I came to understand it as a positive obligation and law as an action, that we just were not going to talk trash. We just weren't going to make it difficult for people who didn't agree, or people who lived a different lifestyle, people who didn't participate in the same cultural, religious, or linguistic relations or ceremonies that we did, that we had no business defining what that is for them, that that's theirs. So to be able to live in terms of Kiam, keep your mind and heart based on the wellness of your own people and family, mind your business, has become quite an informing and informative way to approach the practice of Indigenous laws and legal orders. Because on the other side of that, when I think about a lot of law, Canadian law, Western law, is about policing and policing your neighbors and getting into everybody's business. And I try to think of those places of friction and dissonance as learning spaces. So I don't have to think of this as either or. I have to think about spaces in the middle as well, where there is crossover. And that brings me to the conclusion. How do we move forward with this as a knowledge base? Well, I hope that for those of you who have hung on this long, that as a knowledge base, you've taken upon yourself, like Sophie, to figure out whose territory you're on, that you can say it in the language that it's meant to be pronounced in, and that you start to engage with or commit to the possibility of learning how to be a lawful relative. You can be a relative twice removed by cousinhood, not by blood. There's all sorts of precedents for differing relationships, but you are living in relation to this territory, and you have to find out what that means. I have to find out what that means, or we risk doing or perpetuating the violence of silencing and erasure that has happened since people came to Canada who were not of this land. I often tell people that in terms of legal engagement, instead of thinking of Indigenous laws here as a binary and Canadian laws here, that we should start to think about how these things are related to each other, how Canadian law is related to Indigenous laws and legal orders. When you're forming your understandings and your thinkings, when students and learners are forming your thinkings and understandings, it's really important to have whole ideas. Canadian law schools are generally this. They are Canadian law. A solid mass that you approach as a way to learn, a way to speak, a way to think, a way to read, a way to categorize. And I think we're quite clear on that. I also think that as an Indigenous person who's third generation urban, who had to find and make ties to differing communities and relations to be able to understand it, that my understanding of acceptable, unacceptable behavior, of legal standards and knowledge became incumbent upon me to find out, and I'm still finding out what Cree legal orders and laws look like, and I make mistakes all of the time. But I think that when I was 19 to maybe 29 years old, when I started going to ceremony, started going to the Sweat Lodge, started going through the process of learning Indigenous laws and legal orders, that I started to see that there were times when when Canadian law bumped up against Indigenous law. In fact, all Supreme Court of Canada decisions are ultimately about a disruption of or an impact between Canadian lawful understandings and Indigenous lawful obligations. That's the space within which a lot of this crossover took place, and in which we have uncomfortable conversations. So in terms of this relationality, this area here is my conclusive thought, that you're going to be exposed to Canadian law, Canadian legal thinking in the news, on TV, on television programs, newspapers, on blogs. You're going to have access to that. I think that having access to accurate, informed, respectful, and responsive Indigenous legal orders requires work. And it requires work not just from individuals who can use that as an undertaking to advance the way that they think and talk. I think that it also requires institutions to rethink how it is that they query, interrogate, support, renew, establish relationships with Indigenous laws, Indigenous lands, and Indigenous peoples. And that pulling up of that space in between here where we are uncomfortable, where we find discomfort, that we're going to have to find ways to have conversations about that in classrooms, outside of classrooms, in courtrooms, in bedrooms, in bathrooms, and at kitchen tables. Thank you so much for listening today. I'm proud to have been a part of this series, and I hope that you start to think about whose land you're on. If it's your land, then think about how it is that you're going to have that conversation, if you're going to have that conversation with people who are moving around it, to it. Thank you.